So first, I wanted to say thank you to the folks who participated in last month's backyard forestry. Kristen Umansky from Vernon Township, the tax assessor, Jeremy Caggiano from the New Jersey Forest Service, and Andy Bennett, forester, who's on the phone with us tonight. Really appreciate the work they did. It was a very, very strong Q&A at the end of that event, and we're looking forward to answering some questions tonight as well. Just a little hint, anybody out there who has a farmland assessed property, the above, they're due on August 1st. You have no choice. Save the date every third Thursday of the month, and we'll be telling you about the upcoming program now. We're going to be joined by Professor Dan Duran. Dan is the Assistant Professor of Environmental Science at Rowan University, and he is an extraordinary presenter, very, very outgoing presenter, very enjoyable to watch. And he is going to speak on the important role of young successional forests and how they promote biodiversity and healthy ecosystems. Do not miss. He is absolutely wonderful. We also have another program going on in September from the 19th to the 22nd. It's the New Jersey Woodland Stewards Program. It is an immersive 3.5-day program. We are very well subscribed this year. Something has caused a lot of interest in it. And so if you want to register, go to our website and click on the link. But if you find that you are waitlisted, put your name on the waitlist. We always try to watch for cancellations if someone can't make it. And sometimes we add a few extra seats as well. So please consider it and register. If you missed one of our presentations, go to our YouTube channel. You can scroll through any of our presentations going back over time and watch a video. Finally, if you feel generous, please give to the NJFA. We can use any help we can get. If you want to join, we appreciate your membership. If you want to give a small donation, that's as much appreciated as any other. Thank you. And tonight, two prominent attorneys are joining us, Basil O'Connor and Elenora Benz. They have years and years of experience, decades of experience, each of them, and they're here to help us because we're encountering an issue in woodland ownership, which is mortality and aging. And if the statistics are actually, these statistics are probably a bit understated because they're a couple of years back when they were developed, but the average age of a woodland owner in New Jersey, 65, and nearly 25% of woodlands are managed by persons 75 and older. So we're facing that mortality, that aging. I'm in that group, and we have a coming up generation that is not necessarily ready to assume the work that we were willing to do, and we want to have our properties be our legacy, and we're here to learn about that tonight. Elenora Benz is one of our presenters. She has 30 years in law and exclusively devoted to the practice of estates and trusts and planning. And she is an AV preeminent rated bar member by Martindale-Hubbell. She graduated from St. Elizabeth's University and New York Law School. And she's a member of New Jersey, New York bars, Bar of Sussex County, and she's a forest property owner. Basil O'Connor is also a graduate of New York Law School. He went to Rutgers College undergrad. He has 40 years of experience, and he's also highly rated with Martindale-Hubbell. He's a member of the bars of New York and New Jersey. So without further ado, we are going to proceed with the event, but I'm going to make one point very clear. These attorneys are joining us as volunteers, and they're making a presentation for general purposes only. The suggestions presented, and I'm reading this verbatim for their benefit, this evening should not be construed as formal legal advice, nor does this presentation create an attorney-client relationship. They urge you to consult with your own independent legal counsel if you wish to pursue any suggestions made in this meeting. Okay, I'll turn it over to our guests.
Well, good evening, everyone. I'm thrilled to be here. Yes, I am a forest owner, and it's a wonderful thing to be a part of. And I'm very aware of the Forestry Association because I live with that man in the lower left-hand corner, as my husband is Rich Kelsky. My colleague Basil O'Connor and I have worked together on many mutual clients. We always have a good time and we share great ideas. And I think that he's going to start off with a little, oh, there's a Sainese person on. Hello, Sainese. He's going to start with some background generally about a tax overview, if you will.
Thanks. Thank you, Ellie. You know, some of the questions that were put in ahead of time involved how am I going to deal with taxes and so forth. And one of the questions dealt with someone leaving their property to their children. Well, if you're a New Jersey resident, you don't have to worry about New Jersey inheritance taxes because there are none on gifts to children, grandchildren, and so forth. You also, unless you have a very large estate, don't have to worry too much about federal estate taxes. Currently, the exemption is over $12 million per person. It's slated to reduce down to about 7 million next year, depending on what the Congress does. And we never really know what they're going to do. But unless you're in that category, you don't have to worry too much about taxes as long as you're leaving your property to what we call Class A beneficiaries, children, grandchildren. Nieces and nephews, on the other hand, are 15%ers for inheritance tax purposes. So if you have that situation, you should be very careful about planning for how you're going to pay the tax. The federal tax, if you're subject to it, there are some exemptions, some help. There's a special farmland valuation program under Section 2032A, which can be helpful. And also there's the small business help, which is under Section 6166 of the code. Both of those are relief sections, and they are liberally applied. Hopefully, if you are in that situation, you'll take advantage of that. So tax-wise, that's about the situation as far as death, tax, and succession. Ellie, you're going to talk a little bit about preliminary things you have to think about. We wanted to clear the air on the tax situation. I think, Ellie, you want to talk a little bit about first steps.
Yes, first steps. So I had a family in this week, and they're my stars because I recommended that the older generation come in and bring their children and their grandchildren if they wanted to, so that we could sit together and talk about what the parents hope to accomplish in terms of their succession planning. They were not Woodland owners, but the idea that they were willing to sit down with their children and spouses and have this discussion. And it was really, really beneficial to all of them. The opinions of the younger generation were quite enlightening to me as a planner. Oh, Dad, you can't do that. Well, Dad can if he wants to, but it's critical, and especially for farm and woodland owners who are in the situation where who the heck is going to take over the management of this property if, number one, I become incapacitated sometime in the foreseeable future, or when I die. What's going to become of the property? Who's going to step up? And this is something that can be addressed in a family meeting. It's where the parents will either be delighted or shocked as to what the children really feel about the property. that means so much to the parents. Many of you are woodland owners, woodlot owners, and you love your property. And well, you should, because it's such a beneficial part of our environment. And you want nothing more than for it to continue as a woodland or as a farm. And if you don't have family members who are feeling the same way you do, maybe they live in the city, they have an important job. You say, how the heck would I ever be able to do what you do, mom and dad? Or the alternative is I could do it, but I have absolutely no interest in doing it. I'm planning to move to California. So sorry. And then you have the situations where there are multiple siblings and one of them has worked that woodlot with mom and dad, his or her entire growing up life, and it continues to do that. So what becomes of the other siblings when you have someone who is really interested and you want them to continue with the property? So family meetings for me are absolutely essential in terms of succession planning for your property, whether it be a woodland or a farm. And I know, Basil, you've had similar situations.
I have, Ellie, and one of the things that I think is really important for those of you who do have woodland property and you're thinking about the future, and you should be, is what is your mission? You know, what is your passion? What is your goal? What is your vision? Where do you want to see this property end up? How, in the best of all possible worlds? And even before you get to your family meeting, you should have a pretty clear idea of what you would like to happen. And in order to do that, and then sit down with everybody and say, look, this is what I foresee, this is what I would like to have happen. And I'm curious as to what the rest of you think. And as Ellie mentioned, not just the children, but their spouses. Because very often that's going to be a quote family decision. The management of a woodlot property is well, it's not easy. I don't have to tell you that. A lot of effort, a lot of physical effort, a lot of mental effort, a lot of moving parts. And so you really want to have, as Ellie mentioned, that family meeting. And sometimes most people, when they have multiple children, want to treat them, they say equally. And the idea that, as Ellie pointed out, that you have a child who has worked on that property for most of their adult life, maybe even when they were children, when others have not, maybe equally isn't the right way to manage this, and equitably would be a better alternative, because that child has put their heart and soul into that property. So
they're good questions. They're good questions.
Yeah.
Yeah.
So do you think it would be a good time to maybe do an audience poll?
Sure.
yeah,
Which
we
one,
could do that. Sure.
which one do you want to do?
We're gonna do the basic will question.
Okay. Hang in there, gang,
Okay, everybody participate.
please. And it's anonymous, so don't worry about answering it.
Well, we're gonna try to. There we go. Continue. All righty. The poll is open. First question is, do you have a will? It's a single choice question. And the second question deals with when it was last updated.
I believe they can
Okay.
just click on the.
Yeah, they can click on the screen. They shouldn't answer
Yep.
it in
Oh,
chat.
no, we're doing very well. We're doing
Okay.
great.
I
Okay.
saw somebody
Um,
answering in chat and you don't want to do that.
Yep. Right, exactly. So 70 of the respondents of 45, 78% said yes, they have a will, 22% said no. And 0 to 5 years, slightly smaller group responded to question 2. but was 58% 0 to 5, 22% 6 to 10, and 11% 11 to 15.
Wow.
Have to say I'm impressed.
Yeah, I am too,
And
because,
a small percentage, 8%, was greater than 15.
yeah, I have to say that that is not the norm when you talk about people
Well,
throughout.
we talked about this in advance of this.
Yeah,
And
it's usually about 1/3 of
First.
people surveyed have actually have a will, and most are older than 10 years. So we really, this group has really been on the ball. I commend you all, because that's an incredibly high percentage. It's double the national average. So I'm impressed.
Yeah, I'm speechless. I think it's
Yeah.
wonderful.
Yeah.
Somebody said maybe we're all old. Yes, we are all old.
No, it's
I
almost
have a
up to that.
lot of old clients who were coming in for the first time in their 70s and 80s and said, we think it's about time we did a will.
Yeah, and
Well-
there was one of the questions asked ahead of time. Well, how old do you have to be to have a will?
Good
Well, in the
question.
state of New Jersey, you have to be over the age of 18 to make a will. You have to be an adult. And when should you do it? Probably any time you have any assets or children, and you want someone other than the state of New Jersey to decide who gets those assets.
So now that you've raised that question, Basil, or that point, we have two questions in the chat which kind of flow from what both of you were covering. One is, I don't know if you could see it, I have a Woodland property but no children. Will you address this situation?
We
Yeah.
will.
And then the other is, I'd appreciate a brief discussion of succession planning beyond family members.
Okay, that's good questions, both of them. And there were actually several pre-event questions submitted dealing with the same thing. Not everybody has children to take over the property, and some people don't have any family relatives at all to take it over, or if they do have family, they're not interested in doing this or physically incapable of doing it. And that's a significant problem. There are a lot of answers to this question, or potential, depending on the circumstances, of course. One of the ways is to simply deed restrict the property or sell the development rights, something like that. That's a pretty complicated situation. I guess the other thing you could do is to simply donate it to an organization that will continue and has the capability of managing the property. And of course, the alternative is, if there's someone that you know is willing to purchase the property and continue the property, continue the Woodland operation, that would be fine also, assuming they have the resources to purchase the property to begin with and the capability. Ellie, what do you think about?
Well, think we should explain a little more in detail about deed restrictions and how that would impact the property. So somebody comes along and wants to buy your property, but you want it to be maintained as a woodland. You have to put that in your contract that you are going to, yes, I'll sell it to you, but you must continue it as a woodland, and that will scare a lot of people away.
Well, the other problem is, how would that actually ever be technically enforced in the future? It's really very difficult if you're dealing with an individual owner, acquirer, and then they sell it to the next person, and that's a highly there's a risk of dilution of that desire. And so, what I think Basil had mentioned, perhaps finding a conservation organization, and even
Selling the
that.
development rights.
Yeah. Right. Well, there's development rights and there's fee and there's donation. And I see a question here in the Q&A, which is sort of related. Someone obviously is either involved in doing this or did this. Do you see the qualified land trust question?
No, I don't.
Oh, if one sold one's property to a qualified land trust at below appraised value, e.g. a bargain sale, is there a limit to how much one can claim as a charitable deduction?
Yes, there is. And I'm not going to get into the specifics of it, but it's limited to a percentage of your adjusted gross income every year. You can carry forward any excess amount that's deductible for up to 5 years. And then after that, you lose it.
And
So, yeah,
Right, but if the question was rephrased a little bit to say, is there a limit on the appraised value of the property? And we
so-
talked about this a little bit
Yes.
yesterday, which is if the appraised value that you wish to assert is the value of the donation, be
Mhm.
above and beyond the
Right,
bargain
so an
sale amount.
organization comes in and offers you $500,000 for the property. You have it appraised at the time that you go to contract, and it appraises somewhere around $500,000. The deal goes on and on and on, which they tend to do. It can take a couple of years to complete that kind of a transaction, and the market goes crazy for land. And so you have it appraised again, and it appraises at $700,000. Now you're in that bargain sale position. You need to have 2 qualified appraisals, and you need to submit them when you make your claim for a charitable deduction. I mean, the IRS isn't going to take your word for it. They
no,
want
they
to see
don't.
the appraisals. Basil has worked in the Internal Revenue early in his career, and he could share some more stories with
Right.
you. on
And again, I think there's just a little more detail and like Basil said earlier, we can't answer questions, down to the line item on a tax
Specifically, yeah,
form
they can't.
on this call, but there are other imputed limits which could come into play dealing with your basis in the property and other implications of that. So you really need to involve not only your own attorney, but your accountant as well.
You bet.
And you would do that not when you're in the middle of the deal, but when you're starting to negotiate the deal.
Well, that leads me right into assembling the team.
Yeah,
We try not to do these kind of planning events in a vacuum. You need a team around you. Who should be on that team? You need an estate planning attorney. You definitely need a CPA who is familiar with things charitable. Not all of them are. I would involve your financial planner to make sure that if you're going to donate this, what are you going to live on in the meantime? And then the very important person who's sitting in the lower right-hand corner there behind a blank screen is your forester, who can give you some sense of, well, what is this property in terms of value as a woodland? Is it, is it scrub pine, or is it got good hardwoods, or what is it that makes it so valuable that some organization wants to acquire it? So if Andy has anything he wants to say about that, he can pop right in.
Well, it could be, yeah. Does it have particular significance either as habitats or as perhaps more mature woodlands that they're interested in preserving, or other aspects that are how does it fit into their overall plan
Right.
for acquisition of property in the state or in your area? These are all very complex questions, to say
they
the
are
least.
complex. Well, the whole
And-
process is complex.
Yeah, in fact, one of the backyard forestries that we're considering doing right now is a takeoff on something some of the conservation organizations organized last month, which is having multiple conservation organizations give their viewpoints and explain how they do their transactions and what type of transactions they do. Do they do easements? Do they do fee transactions?
Right.
And how do they structure their transactions? So we're looking at that. So stay tuned for it. Now I see another question here that's 2 more questions that are interesting, but one will, I guess it says, we already have a Highlands conservation easement. I assume it transfers to any future owner. I assume if it's a recorded easement,
Yeah, I'm thinking
then
it goes with
it goes
runs
with the
land.
property,
Easements
right? But
run with the land, correct.
right, assuming you've correctly defined it as a conservation easement, Yeah, we can't read the papers during the webinar, but
Yeah,
but if it's a recorded true conservation easement, then it will be recorded in the county clerk's office and will reflect restrictions on the use of the property
That is
for
correct.
which you received value.
That is correct. There's a really interesting question in there. I don't know if we can really address it, but we could take a stab at it. I want to donate inherited property to conservation, but my brother does not. What do I do?
Oh.
Well,
Immediately stop talking to them.
right.
That's,
No,
yeah,
That's a sticky wicket, and short of doing a partition suit, I guess, to get your brother out of the picture, I don't know how you could do that unless they cooperate.
well, the question really is what else was in the estate other than the property, and how was that distributed?
right.
Because if there are assets and you have you're in a different financial position than your brother, and you are looking for that donation, let's say, for conservation, and your brother's not, maybe you can do something to reapportion the assets that you received as part of the total. What do you folks think as a panel?
Yeah, I mean, that would work. I'm not sure if the two brothers are inheriting this property or they happen to be partners in the property.
Right.
If they're inheriting.
Not clear
property-
from the question. The question is, I want to donate our inherited property to conservation. So it sounds like they already own it together.
Yeah, that's what it sounds like. They've inherited the property and they don't agree on the disposition of it.
Right.
And I guess the first question I'd ask them if I was their attorney and I was sitting in front of them, I'd say, well, which one of you guys is gonna manage the woodland? How are you gonna deal with this?
Right.
And I think sometimes people either don't understand or don't want to understand the amount of effort that goes into dealing with this. It's a hard situation. Besides having a real heart to heart with your brother and yourself to understand.
All right,
It
they backed up
it
their
is you
question
both
with
wanna
another
get in.
statement. They say we own it together and there were no other assets to divide.
Oh,
That's even worse. Yeah, that's a tough one.
yeah, well, you're gonna have to come to some agreement. You own the property as tenancy in common when you inherit property like that. That means you each own a half interest effectively. But it's not a divided interest. There's no subdivision or anything. I don't know how large your property is. If you could subdivide it, I guess that's something you could think about, but.
Yeah.
Then I guess the problem then is selling the easement. The size of the property, the bigger it is, the more attractive it is to one of these organizations that would be interested in buying it, I would think.
Yeah.
Rich?
I mean, from my perspective, I mean, these kind of family disputes get very difficult and get very ugly very quickly.
Yeah,
Might be something that one would consider either formal or informal mediation of the issue, having two councils get together or bringing in a mediator or something but without the idea of I'm suing somebody. I'm not going there for
Yeah.
this. My thought is keep it peaceful and get the issues on the table. What's the tax benefit? What's the money coming in? How much will come from the conservation organization? How much will you get? How much will I get? Is it enough to fight about? And these kind of questions and figure it out and go back to a word that Basil used, equitable, some kind of an equitable solution that's worked out.
And it's obvious to me that the questioner, they've been dealing with this for quite some time now, and hopefully they each have their own counsel and they're getting good advice, because this is not something we can solve here.
That's correct. That's correct.
I think we have another poll question.
Sure, we do. This is a corollary to the first one.
That's
So we'll do it. Power of attorney. Do you have a current power of attorney? And we're not talking about a living will or a healthcare advance directive. It's a true power of attorney. Wow, that shifted quickly.
Aha.
63% yes, 37% no.
This is a great crowd.
Yeah, this is an important document.
Oh, critical. Critical.
So,
I tell my families that if they have family members over the age of 18, every single one of them needs a power of attorney. And Basil and I could tell you horror stories all night long about what happens when a child has assets. It's an emancipated adult. They have assets, but they have no wife, no children of their own yet. And they get into some kind of terrible either health situation or a terrible accident, and they're incapacitated, and nobody can get at their assets and manage them without that documentation. So we end up having to get a guardianship over this person, and that's just a disaster.
Well, it's expensive and time consuming.
Yep.
And unnecessarily so, because a power of attorney is a relatively straightforward document and can be prepared very little cost. But you have to be careful about who you give that document to.
Right.
Most of our powers of attorney are done, they're durable, which means they work even after you're incapacitated, which of course is very important because when you really need it is when you are incapacitated. And most of them are general. What that means is that the person who is your agent, the person you're given the power to, can essentially do any financial transaction that you can do. In fact, they could probably do anything you can do except sign a will,
Right.
sign a marriage license application,
Right.
and they also can't sign a divorce complaint. But beyond that, they can do almost anything. So the document is a very powerful document. It's a very important document, but should be safeguarded. And you should pick your agent very carefully, but they are very, very critical. And frankly, they're usually part of the program. When we do planning for someone, typically you think of, we're going to do a will, but in almost every case, we're doing a power of attorney and we're doing advanced directive for healthcare at the same time, because all these documents work together.
One thing we didn't ask in the poll, and just food for thought, for those of you 67% who do have a power of attorney, if you've never presented it for enforcement anywhere and it's more than 10 years old, the financial institution can say, no, we won't accept it. So
look at the question in the Q&A right on there.
Oh, is it really?
Look at that.
Hello.
I thought you were cheating and you had the
No,
you hit the
that's a
right
great
subject.
question.
Wow. That's
Yes,
fantastic.
because it was probably too old, but there's certain, I don't know where you live, but there are certain financial institutions that give everybody a rash of you know what when they bring in power of attorney because it isn't on their form.
Right, but don't mention their names.
Right, we won't name names, but the whole purpose of the New Jersey power of attorney statute is so that you have one document that works everywhere instead of you having to go from institution to institution signing their form. And then when you want to change who you gave the power to, then you have to revisit all of those institutions and do that again. And some of us are old enough to remember back in the 80s when interest rates were hanging in around 18% and every bank was giving away a TV or a microwave or whatever. And all the little old lady and little old men clients were running around to all these banks and getting their gift for opening an account and signing the bank's form of power of attorney. And then they got mad at the person they wanted, and it was just a mess. So that's the purpose of the New Jersey durable power of attorney statute. And while the documents are very easy to create, be careful about the ones that are online. That's all I'm going to say about online documents.
There was a question about, is there a statute that limits the age of a power of attorney And Ellie, I think you referred to it as,
Yes, a
if it's
10-year.
older, yeah, if it's older than 10 years.
They can refuse it if they haven't seen it before. They may
Right.
not necessarily refuse it, but there are some institutions that absolutely will refuse it if it's too.
Yeah, yeah,
The fear being, and I guess the fear was, oh, well, maybe that person has changed their mind over time, or
Yeah.
maybe they're not even alive, who knows?
yeah. Well, of course, that's a good point because when you pass away, your power of attorney is gone also, that ends. So that there is a finite point at which it's no longer effective.
So I would just comment where a person said, how do they get away with refusing to honor it? The answer is
Yeah.
because they can. And the parallel answer to that is you need to join the 66% group who do have a power of attorney. And then we didn't ask them how old is it, but if we take a lesson from the wills, they're probably fairly recent.
Right.
And remember to update it and review it because you've given a person a lot of power. And if your relationship changes or your circumstances change, time to change your power of attorney.
Yeah, and to the question of should they present these powers of attorney to their financial institutions, not unless you need
Yeah,
to.
we don't recommend that.
No, don't, we also don't recommend sharing our estate planning documents with family members. Too much information too soon. Family meeting is one thing, but documents, just handing out documents willy-nilly, we do not recommend.
Yeah, it's interesting. Clients have two schools of thought on that. Some of the clients actually want their children to know or their beneficiaries to know, so they're prepared, which I guess is a reasonable feeling. But then if one of them, and I have a situation, if one of them doesn't like it and then tries to convince the parent to change the
Right.
will, it gets to be pretty ugly. So, I would say most do not share the information, do not share a will. And you can tell them, I have a power of attorney, it's in my safe, or it's in my cabinet, or it's under lock and key, or whatever. So if anything happens to me, let me know. The other thing you can do is just say, well, Mr. Smith or Miss Jones has prepared my estate planning documents, and if anything happens to me, give them a call.
Yep.
And because typically we'll keep one original of clients' documents so that they're available in case of emergency.
The other problem is if you, for instance, on the power of attorney especially, you appoint one or the other of your children to be your agent under this power of attorney, and you hand out copies, and then you change your mind about that relationship, and you're going to change the power of attorney, you got to get back the ones that are out there, because who's going to say they're not still in effect? So we really don't recommend that you share.
And
So just to go over that one more time, you sign your will, you sign a power of attorney, and whatever other related documents are in this package, but don't give them to anybody and have them. I guess most typically is they're held by the attorney, and when the person they get notice that the person passed away, they then distribute them to the appropriate party
or if there's a need, I mean,
or incapacity.
yeah, if somebody's in a hospital, they've signed the advance directive and they can't seem to find one. Sometimes they'll call the office and we'll scan and send a copy of it, to the medical facility. But you have to be careful about that, and we have to be, as attorneys, we have to be very careful about that.
What I try to do with my clients is I provide them with a thing I created called a family information record. Doesn't give away any confidential information, but at least says, these are the kinds of documents I signed, and here's where they live in case you need them in my absence, or if I'm incapacitated, or when I die.
Yeah. Yep.
So you got your team assembled, right? Everybody's getting their team together to work on after they have their family meeting. So now you're gonna sit down and talk with your attorney about a basic estate plan. So what should be in that? And we had a really good question about whether it should be a revocable trust or a will. I will tell you, and I think Basil does the same thing, when he sees these revocable trusts that came out of a can, and the client comes in and says, I don't know what the heck this thing is, and I just signed it, and it's 57 pages long. And the only thing different about yours and your neighbors is name and address. There's nothing to fear about probate in New Jersey, and I think Basil can back me up on that one. He's done a lot of probate in his career, and so have I. New Jersey is one of the most user-friendly states when it comes to probating a will. Takes all of about 15 minutes in the surrogate's office because you send everything in advance. And there you go. You get your certificates and you're the executor, and off you go and do the work. It's the same work you would have to do. It's just called something different if it were in a revocable trust. Now you've got to follow the terms of the trust and distribute property as it instructs, or you're doing it through the will. So.
Yeah, I would say New Jersey gets a lot of criticism, and sometimes rightfully so. But the one thing we do better than any other state that I've ever had to deal with is probate.
Oh, yeah.
I mean, the surrogate's offices are very friendly, very helpful. The whole process is, as Ellie said, 15 to 20 minutes. You need an original death certificate, the original will, and you need a list of the heirs at law and beneficiaries, and their addresses. And the cost typically is less than $200 to do this, and you never have to go back again unless there's a problem. And when I compare that to the other area, I stopped.
New York.
Yeah, I'm practicing in New York. I mean,
Oh
the
my
whole
gosh.
process can cost several thousands of dollars before you even do anything. And it's terrible. So in New York, we frequently use revocable trusts. You still have a will because some assets or another might not get retitled in the name of the trust. But it allows you to start the process of dealing with an estate through the trust without having to go through the probate proceeding. Or if you do have to go through the probate proceeding and most of the assets are in the name of the trust, you can pay bills and distribute assets and do things while you're waiting for the surrogate's office to issue a temporary letters of administration, and then you have to go back. I mean, it's amazing. And some other.
Basil, you're talking about New York, right? At
Yes.
the moment? That's what, yeah, okay. I just want to make sure people understood that.
Yeah, it's ugly. New
The
Jersey,
difference between the two states, it's simple.
yeah,
New
it's,
Jersey will do anything it can to get your will admitted to probate without a hassle. New York does everything it can to prevent you from getting your will admitted to probate.
that's a pretty good description, yeah.
So there's
There's a question here about a POA.
Yeah,
just
it's a
came up.
wonderful question too. 93-year-old man with failing memory has one competent relative to take over financial affairs, signed a power of attorney last year. Chase Bank wants a letter from the attorney that the relative was competent when the POA was signed. Well, it's interesting because New Jersey doesn't require witnesses on a power of attorney. It does require that the signer's signature be acknowledged by whoever did it, usually the attorney. I require witnesses on mine because the more people who were there when you signed that power of attorney, which is a critically important document and vests a lot of power in the person that you appoint, you want to make sure that person has a very high level of capacity to sign that document. It's so much higher than the capacity required to sign a will, for instance. I don't know why the attorney wouldn't comply and give that letter. I mean, that's just a no-brainer, I think.
Yeah, in New Jersey, you're assumed to be competent unless you're proven otherwise.
That's right.
Chase actually has no right to ask for that letter. Nevertheless, sometimes it's easier to just go along with them to get the thing situated, and I'm sure the attorney, I would imagine the attorney would sign a simple letter saying, when he signed this, or he was fine.
That's the difficulty with dealing with financial institutions that are not resident in New Jersey. They're not New Jersey organizations. They'll give you a problem like you're experiencing with this power of attorney. They do the same thing when it comes to probate. They make executors do things that are absolutely not required under our law. And yet, if you want to get at the assets, you better comply. So it's really, you're held hostage by certain financial institutions, and I will not name others, but they're out there.
Yeah, it's basically taking the path of least resistance, like water and electricity, because sometimes it just doesn't pay to fight them. It delays things and it's not worth it.
So basic estate plan, absolutely need a will. Die without a will, it's a disaster. Okay, you don't get to say who manages your estate, and you don't get to say in what proportion people get it. And doesn't matter if they're competent or not competent, they're entitled to a distribution if you don't have a will and they're your kids. So your will allows you to override those things in our state statutes that you wouldn't want to have happen in your estate. You get to pick who runs the show. You get to pick some backup people to that. You can decide whether or not the distributions are going to be made outright or in trust. There's all kinds of versatility and flexibility that go along with having a will that absolutely do not exist if you die without one.
If we look at the purpose of this webinar, you could never accomplish
That's right.
anything with respect to your desires for the property without a will. Is that correct?
That's correct.
I would think that's correct, yes. And
So-
certainly it makes it a lot more practical to actually make things happen when you have a will. It's your outline for what happens after you're gone. And
Right. And I would hate to see somebody with a beautiful woodland property dies without a will, and somebody comes in at a fire sale, the beneficiary, the distributees of the estate have no clue as to what should really happen. And they end up selling it because they don't know what else to do with it. And there goes the woodland. So the other 27% or so of you that don't have wills, go see your attorneys and get one.
please,
Please. We also emphasize the importance of the durable power of attorney. I have 18-year-old clients that have them, and let me name their father or their mother as their agent under the power of attorney, and that'll do until they have a more established life. But they have a couple of bank accounts and they have a car, and again, if something happens to their capacity, nobody can do anything with those assets. Another thing you want to consider is in New Jersey, we call it a living will or an advance directive. That's for your wishes with respect to your terminal care. And in that, we incorporate, do you do a separate one? I do it within the living will.
I do the combined. Yeah, I do combined.
Yeah, combined document that has the person you want to be in charge of your care decisions if you can't make them yourself. And that's as basic as you can get for an estate plan.
Yeah.
And the sky's the limit after that. Somebody wants to talk about carbon credits.
Well, it's
Don't look
certainly,
at
we can
me.
talk about carbon credits,
Yeah,
but
please.
in sum and substance, these are, in rough terms, credits, economic money given to landowners for not cutting trees, in essence, and maintaining the carbon stocks on their land. Carbon credits in New Jersey are still in a very large state of flux. There are companies that have come and gone. There are others that have altered their programs since the first day they came out. And some of them are annual programs. that you have the choice to renew annually, so they could be a source of short-term income for Woodland owners without a long-term commitment. But you have to be careful also that they don't contain provisions that say, if you're, for example, if your management plan says that you're going to conduct certain activities, that they don't prohibit those activities from being conducted. And even in selling a conservation easement, some of those easements, the pre-easement agreements will say you cannot conduct a harvest on the property pending the closing of the easement, because they don't want the nature and character of the property dramatically altered without their approval before they purchase that easement. So these are things you have to take into account in balancing that. Carbon credits will take a lot of research for each individual to see what plan is being proposed to you at that moment.
There's a great question in the Q&A. I own land in New Jersey, but I live in another state. Potential problems with enforcement of the will and power of attorney?
Well, under New Jersey law and under most states, I don't know what state you're a resident of, but most states do recognize documents from other states. It's called comedy, not like, Saturday Night Live comedy.
The other comedy.
Yeah, but it's so it's probably okay. But if you're here a lot, I have clients that live in, say, Florida, and they're here quite a bit. I recommend that they have a power of attorney drafted like we produce them, with references to New Jersey statutes, so that any financial institution that we're asking to recognize it, it's not a foreign document.
Right.
That's powers of attorney. Living your wills, your actual will is still valid. If it's valid in the state where it was signed, it's valid in the state of New Jersey. Again, we do have slightly different rules. We only require 2 witnesses. We have a self-proving will provision. It may not comply with that, so there may be some issues as far as having the will admitted to probate. If you pass away in another state and your will is admitted to probate in that state, and an executor or personal representative is appointed, that person can act in New Jersey. We used to do something called ancillary probate, but in recent years, the surrogate's offices, for the most part, will not do an ancillary probate proceeding and then give you a document to act. And I'm not exactly sure why. I've spoken to the Sussex County prosecutor, the Sussex County surrogate about this, and they just have been advised by the Supreme Court not to do it. And I don't understand.
I don't get it.
Yeah, I don't either. But you could still act, if the executor could still act if they're qualified in the state where a person passed away. So.
It's a great question. Thank you. I'd like to go back a little bit on the questions about our attendees who have no one to leave the property to. And I was joking around in our pre-session, and I was waving this and saying, this is my magic wand. I wish it really worked, because I think we need one. It's a very difficult situation unless you are charitably inclined or you want to deal with a conservation organization. If you have no one, don't just pick a more remote family member just because you think it should be family. You need to, this is where you sit with your forester and have your forester evaluate your land as to its worth to organizations, and start now, thinking about it now. Don't wait until you're really not feeling well or some life event has happened that's going to prevent you from being actively involved in this kind of planning. There are things you can do. There are ways to go. If, as Basil said earlier, if you have this mission in your mind that this is what you want to have happen, you want this to remain as a woodland and never be developed, now is the time to really start moving forward with that mission and finding the help that you need, the gathering of your team to say, hey, team, what can we do? And, 3 or 4 heads are definitely better than one. You're not in it alone if you have a team around you and you have the land that you want to see preserved.
Yeah, this is a terrible problem. I mean, and I think having an organization like New Jersey Forestry Association and being active with that group and meeting other people in the same line of
Yep.
activity, people who are managing woodlots and dealing with these issues on a daily basis, are familiar with what it takes, and getting to know those folks, it's possible you'll meet somebody that can take over your property, either purchasing it or purchasing it at a bargain sale or whatever. But just so the property continues to be woodland property in the future. I suspect there may be contingent properties that you could talk to a neighbor that's got a woodlot as well, if they would be interested in continuing on. I mean, you have to exhaust every possibility. We're talking about carbon credits and so forth, but these properties, these woodlands absorb carbon at a hell of a rate. And it's important because they also give off oxygen. So we, as human beings, we need oxygen to survive, and we don't need a lot of carbon dioxide in the air. So it's really important to try to get a plan together, understand what it is you're trying to do, what is your vision, and then immediately start working on that vision. And if you don't have somebody, if there's no quote natural progression of people that take the property, find somebody, because there must be people out there who would like maybe to add to their own property holdings, or maybe people that would even want to get into forestry that don't really know how, and you never know. I mean, I think you have to try.
So there's really, we talked a little bit about taxes at the beginning of the presentation. Now, there's a great question here. It says, for me, the question is not about having someone to leave the property to. It's probably more of how can one minimize the taxes if the land is left intentionally to non-family members? Good question. And
Yeah,
there's a corollary question in the Q&A. I'm sorry. I think we can answer them together. In considering a possible transfer of woodland or farmland to an individual who is not your child, but who is an appropriate candidate to continue farming the land and furthering the will of the landowner, is there a way for them to initiate inheriting, quote unquote, the land similar to a child?
that's a very
Great questions.
It is
going to law school, guys.
Well, here's a thing that I didn't talk about. New Jersey does not have a gift tax.
No gift tax.
I don't know how they missed this, but they don't have one.
They don't.
So if you have a nephew or a niece who is interested in carrying on your woodland and managing it, and they have an interest in it, I would find a way to quote gift it to them before you pass away, because if it's not in your estate when you die, there's no inheritance tax on something you don't own.
Well, yeah, the 3-year look back though.
You have a 3-year look back. So if you're thinking about this, you might want to do it sooner than later.
Right.
Is there an annual limit on that gift?
No.
There's no New Jersey gift tax. There's a federal gift
Okay,
tax.
yeah.
Okay,
Federal
so,
We're up to $18,000 per year per person.
right,
However, as I said, your exemption for estate tax is also your exemption for gift tax. And that exemption at the moment is $12 million plus.
right.
So
So, but you know,
There's no-
understand that if you want to do that kind of gifting, you want to do what we call major gifting. Again, you need your team. You need your CPA to be on board because you're going to have to file a gift tax return. You're
right,
not going to pay any gift tax, but you need to file the return.
You're
yeah,
not going to pay a New Jersey tax or a federal tax? Or-
Federal,
federal.
and there is no New Jersey gift tax.
All right, so again, you also might want to talk to your financial advisor and your attorney as well.
Do this.
You know, we talk about the team. It's good to have a team, and sometimes it's imperative to have the team. And Andy hasn't been participating here, but Andy Bennett and people like him can talk about and give you a plan to make sure that the person you're thinking about giving this property to is actually knows what it is that they're getting. And then the gift, you know, you'd want to deed restrict it or something.
So this would be the role of the forester, what would be to sit with the person who's potentially getting it and discuss what's in the plan that has to be carried forward.
What do you have to
And
do?
then, look, they're not your lawyer, they're not your psychiatrist, they're not your doctor, but
No.
they do know your property and they can maybe help you assess whether or not the person can actually do what's required to be done going forward. And I just wanted to point something out. There's been a lot of talk about conservation easements, but I think people confuse the short-term cash opportunity of a conservation easement with relief from duties on the property. Does not occur. You
No.
still own the property, and if you want to keep it at farmland assessment level, then you have to qualify for farmland assessment, because the conservation easement alone does not necessarily reduce the assessed value anywhere near to what the farmland assessment assessed value would be.
And you have to file by August 1st, correct?
You have to file by August 1st. Now, if you are sick, if you are sick or incapacitated, you get 1 month's extension, provided you file notice by August 1st that you're sick or incapacitated, or something close to that. It's
When I
pretty
read that-
Machiavellian.
When I
Hi,
read that
Andy.
language,
Welcome
I
back.
said, are you kidding me?
Yeah. So
1
there's
month?
a couple of questions here that I guess relate to the same thing. We're focused very heavily on this unrelated person giving.
Yeah,
And
they can
I
be
think that my
totally
sense is these are
unrelated.
very complicated questions that really need to be discussed with counsel. But there's a good inherent question in there, which is, can you gift property to an unrelated person? I assume taking advantage of the gift tax laws.
Absolutely.
Yes.
It doesn't have to be family members, and it's the same with the annual gift. It can be to anybody.
Yep.
Any person.
Okay. So
And
that's
there, you know, I don't want to go into the federal statute, but there's parts of that are really wonderful opportunities if you had a lot of money that you wanted to give away, but we're not going there tonight. This is all about woodlands.
Mhm.
We have a couple of more polling questions that we haven't looked at yet.
Yep. We'll try a couple. Let's,
I would love to see the one about who's managing the property.
okay, let's see what I can do for you. I have one on property ownership. Are you interested in doing that one?
Sure. Why not?
It would be interesting to know it. Is your property held individually, jointly, or by an entity? Wow, 50% individually, roughly, going down as we speak. 44% individually, 43% jointly,
Okay,
and 15% by an entity.
okay.
So
Not
So,
so. actually.
mostly joint, a little more jointly than individually, but
Okay.
I'm a little bit surprised by 15% as an entity.
Well, somebody's been doing their planning.
Yep.
I'd be curious as a follow along, which we didn't ask, if it's jointly, is it with a spouse? Because as we
Yeah.
all know, spouses are treated better under the tax laws than unrelated people.
And there is, by the way, there is a way in Zoom to create a poll on the fly, but I would probably disconnect
don't.
everybody. And at that point, we'd have a revolution on our hands. So there are actually two other questions I think that we had. One was relating to woodlands. And I
Yes,
think Andy will be interested in this one, which is, do you have a woodland management plan or a forest stewardship plan? Which one? Or do you not have a plan, but you still own woodlands? So that's the first question. And Andy, you have any thoughts on this response? It's kind of interesting.
what's the response? I didn't hear.
60% have a woodland management plan.
Yay.
21% have a forest stewardship plan. 19% say I do not have one of those plans for my woodlands. So that's sort of interesting. If your woodlands are over 5 acres, in addition to at least one or 2 acres for your home site, depending on where you are, then they may be eligible for a plan to be created and for farmland assessment. Is that correct, Andy? Roughly?
Yep, that's right.
Okay, so that 19% of folks would certainly be a good thing to look at. But what I find interesting is the confirmation that 83% are involved in the management of their woodland.
Wow, I like that.
Yeah, but it also shows us the stress that everyone seems to be under in planning
Yeah, no question about that.
because they're carrying that burden on an individual basis.
One of the things that if you're going to have a family meeting, your family needs to understand how much it costs to manage your property, what you need in the way of equipment and maintenance and all of that. That people don't have a clue as to what that. You just got a tractor, right, Andy? You just got a brand new tractor. You have no clue what those things cost and how to maintain them. How many of them could actually maintain the equipment that you already have? So that's another family meeting topic.
I have a question. Actually, this is for Andy. Before the family meeting, would it be important to have both a forest inventory and a forest management or stewardship plan even before the family meeting?
Yeah, I mean, if you have, if you have a woodland property and you have a plan, part of that plan has an inventory. So one of the requirements to do a plan is to create an inventory. So if you have a plan, you should have an inventory of what's out there. Yes.
And do you think that would be important before you actually sit down with the family to talk about it?
I think it'd be great to have a plan in place, yeah, and to have all that information kind of at your fingertips and to have a little bit of a working knowledge of what this all means. Yeah.
Okay.
Well, as you see from the level of individual involvement in the management, most of the owners are very cognizant of the details of their property. And it's a highly involved ownership process. But I think that particularly if that plan is going to lead towards who's going to acquire the property in the future, who's going to receive the property, or if there's going to be a conservation easement or a fee sale to a conservation organization, knowledge of that property is very important, especially when you're evaluating, perhaps they get back to appraisers' valuations on your property for the easement or for a fee purchase. And you would want to have a good command of that because you may want to get your own appraiser to appraise your property. And that plan would be a good guidebook in part for that appraiser to understand the property, aside from just simply driving by the roadside and looking at it. And anyway, and so to me, there's a value in it, but for those who don't have a plan, then they don't have it. And then I don't believe they would create it for the meeting. I think that would be far too costly and complex.
But, and I'm assuming this plan is written. I mean, I assume it's as a lot of steps and things, like this year we're gonna do this, and this year we're gonna do that, and so forth.
Mhm.
I think it would be helpful to know, to have some.
Here's a plan.
Yeah, look at how big it is.
Okay, but I can see son or daughter saying, yes, I definitely want to take over the property. And you hand them the plan and say, read this before you make that statement, because I think it's critically important in knowing who the heirs are and what their abilities and intentions are. Part of it would be they have to know what's involved. And I mean, on sort of a granular level, because, I think the average, I'll tell you the truth, before I kind of boned up a little bit on forestry for this meeting, I think most people think, well, it's woods. And you go in there and occasionally maybe you'll take down some trees, or somebody comes in and says, well, I'd like to harvest, certain trees in your property. And maybe you'd have to go in there and cut the underbrush to keep in case of fire or something. I don't think people recognize how involved this actually is. I mean, on the outside, and I'm talking now about family members who are not involved in this process and coming into a family meeting and being asked, what are your intentions? What are your interests and so forth? It would seem to me they need to know a lot more about what's going on than the average person would know. Am I wrong about that, Andy?
Yeah, I mean, I think just as I've been listening, it seems like that would just be more helpful information as part of this conversation to kind of build firm footing to kind of have these conversations. So yeah, be helpful. And a forester like myself would be happy to, a plan on paper sometimes is hard to understand for somebody who's never looked at anything related to forest management. But to take a walk or to have a 30-minute conversation with a consulting forester would be helpful, just to explain, in writing it sounds like a foreign, reads like a foreign language, but we could just talk it through and explain a few things. It would give them, some good information. So
Oh, this person asked the best question, because I was just going to talk about rollback taxes.
Okay,
Okay, so one of the problems that happens if your property doesn't continue in farmland or woodland management, and the new owner doesn't do it, there's rollback taxes. Who gets the hit for that? And how much is it, and how many years does it cover? And it's all a wonderful question, and it's the bugaboo, rollback taxes. So, Mr. Taxman, Basil, you want to answer that? Okay, so it's 2 years
2 years plus the current year.
plus the current year,
Right.
and who's
And
stuck
they-
for it?
Rollback tax, well, first of all, rollback taxes are triggered by a change in use.
Mm-hmm.
So understand that we have a structure of local tax assessors in the state of New Jersey, and each town has their own tax assessor. Typically they share them among small towns, but the process or the methodology employed in determining whether there's been a change of use could vary tax assessor to tax assessor. So rollback taxes can be pretty costly, because that represents the difference between fully taxed at retail value of the property versus taxed at its income potential value, which is what drives farmland assessment valuations. And it's a huge dollar difference. So there's issues that could arise from rollback taxes during your lifetime. And then there's issues that could arise from rollback taxes during a period of incapacity. And then there's issues that could arise post-sale. And now your question is, who's responsible for them?
Mhm.
And the answer is, you need to specify in your agreement of sale who is going to be responsible for rollback taxes. Because the seller does not want to pray that the buyer complies with the plan and all the farmland assessment requirements. So you need to say that in your contract.
Rich, could you talk a little bit about the woodland management versus forest stewardship? You know, the difference?
That's an Andy question.
All right, Andy, yay.
I don't know.
It depends.
It's getting late.
No, it
Yeah,
depends, right, Andy?
It very much depends. Yeah, it is
No.
pretty it can get complicated depending on the breakdown in acres on your property. If you're a mixed use property, some of those things. But basically, the thrust of forest stewardship, I'll just kind of share more like the kind of the soul of a forest stewardship plan is to have the flexibility to manage your forest according to kind of what the forest needs from you at any moment in time, unrelated to producing necessarily a product. So under the woodland management rules, it was very much focused on producing a product so that you could generate income to meet the farmland assessment rules, which require you to, derive some revenue from your land. Forest stewardship kind of dropped that requirement so that you could do things like, if the forest required, Basil, you mentioned it, managing some of the underbrush, some of the invasive species, or maybe there's an area of your property. I'm working on a plan right now where we're actually going to do some planting to kind of reforest an area of the property. Those are non-revenue, activities. They don't produce any revenue. They're a cost, but they're good for the forest, right? So that's kind of like the biggest differences, I guess, between the two.
Right, but I don't think we should leave it that woodland 90% of what you do under a woodland management plan is not revenue based.
Correct. Yep.
As well. So,
Yep.
I mean, I made up that percentage, but it's very, very similar in that respect.
Mm-hmm.
But it's the absence of a minimum revenue requirement.
Yep. Yeah, and I would just add any revenue generated, the cost was immense to get to that generation of that revenue, typically. So,
we've talked about this many times, Andy. This is owning a woodland property is not an economic,
right.
It's not for economic gain.
Yeah.
It's not for the faint of heart either.
And I guess I take it that the revenue required to be produced is gross revenue, not net.
It's gross. It's gross revenue.
It sounds like it'd never be a net revenue.
No.
Well, it's actually become unbelievably expensive also for people because of the issues that we're dealing with, like the ash crisis and the removal of those trees, and the in essence, most people can't do them themselves anymore because of the hazards, and there's huge costs involved, and this goes on and on. So we feel that pain as we manage these properties, and it's one of our missions is really to get respect for what we do, and for people to understand it and what's involved in it. There is another question in the polls about domestic pets, farm animals, etc., and we'll address why once you answer the question. Do you have domestic pets, indoor or farm, livestock, or board animals for others? This one actually surprises me a little bit. It's 40% yes, 60% no.
Interesting.
It's surprising.
Interesting.
Including
After all, Sussex County, where 20, 30 years ago, there were more cows than people.
That is correct. But if you do have pets or horses or goats. Ellie, maybe you can tell us a little bit about what you need to do from a
And-
planning perspective.
Oh, yes. More with domestic pets, not livestock. You want to have a plan for what would happen to your livestock.
Right.
But for your domestic pets, some people are very worried about being survived by their horses or their dogs or whatever. And in New Jersey and in most states now, you can create a trust for the benefit of the care of those animals.
Yeah, I mean, we know we've experienced it ourselves on our farm. Horse lives 36 years. And when you got that horse, you know, you were a young person riding every day and you aged with the horse.
Right.
And, you know, it's unclear as to who's going to go first.
Right.
And so providing for those animals is essential because you know, there's a history of mistreatment of animals that are not properly provided for under a will.
And
So,
there used to be,
or trust.
farmers would say, well, when I die, you euthanize my animals. And many courts have decided against that kind of thing in a will. That why should the animal die because you did? But yes, you can create trusts for your domestic animals. And when you think about, some people have parrots that live to be 80 years old, and what's gonna happen to them? That's a very big issue with the long-lived animals.
Yep, here's somebody who has 1 million honeybees.
I love that person. They're doing
Yeah,
wonderful
but it's
things for the-
essential to know who's going to take those hives over. And
Exactly.
again, you don't want somebody thinking about it when they've just come from the hospital when you've passed away and they're not paying any attention and those bees just basically die or are neglected. And I see another question here, which is also quite interesting, which is, my daughters know what it is like to manage my forest property and they want nothing to do with it. They want me to sell it now and I'm not ready to do that. Well, then maybe the alternative is to start considering conservation organizations to take your property in fee so that when you sell it, at least the property remains a forest. Whether it's maintained the way you maintain it, that's an open issue that we can discuss for days on end. That depends on the conservation organization, whether the maintenance of the property is pre-funded and other aspects. But there are ways to deal with it so that if you care about it, you can at least increase the odds of a successful transition to a more caring person than somebody who will put up a warehouse or cut down the trees. So, yes.
I would just like to thank the Forestry Association for putting on this webinar. I've done a lot of presentations in my career, and I know Basil has too. This is one of the most sophisticated audiences I've ever had the pleasure of working with, and you are all to be commended on your questions and your attention. I mean, we hardly lost anybody in the last 5 minutes of this webinar, which is also amazing.
You mean the final 5 minutes?
In the final 5 minutes, right?
Yeah,
So
but,
thank you very much for this opportunity.
Oh,
Yes,
I think it's been a
I
great
my
evening.
Thanks as well, because like I said, just even getting ready to do this, I had to do a little bit of background to learn something about it. And what I've learned is remarkable. And frankly, there ought to be more relief provisions in the New Jersey statutes
Well,
Agree.
for,
Yeah.
for farmland, especially woodland. It's just, it's a long-term process. It's not like growing corn,
exactly. One of our members actually worked with a legislator to introduce a bill which is currently alive and is seeking to add woodlands to the agricultural easement program. Is that a fair statement, Andy?
Yeah.
Yeah, so that program could be expanded to include woodlands at the state level, and we hear that it has some traction. So that's certainly something to consider. But as I say, one of the things we are looking at bringing you is a panel of conservation organizations to give their views on woodland acquisition, easements, and future treatment of properties acquired or on which they gain conservation easements. So that's something that we will have probably, I would say, within the next 6 months. So stay tuned for that. And I have to thank you both for all the work you put in preparing for this. And it's been a great seminar. Andy, thanks for joining tonight, as always. I know it's your busiest time of year.
Yeah.
And thank you all for attending. So stay in touch, keep watching. We'll send out a notice on the upcoming August webinar. And thank you so much again.
Welcome.
Thank you.
Night all.
Thank
Good
you.
night.
Good night.
Good night.